note that this is a two-part series. Next week, we will have Christine Seespit of FLX Attorney here to talk about options for aging in place. So if you have not signed up for that program and you would like to attend, I do have a clipboard in the back if you want to just put your name down just so we know how many people to accommodate. Finally, if there is a couple here that would like to share a packet, we do have a couple people who didn't get a packet. You can raise your hand if you need a packet. Oh, did you get one? Okay. And then if anyone else comes in, thank you. Yes, thank you. All right, and I will let you guys take it away. Thank you. Hello?
Okay, that's working. I'm Nancy McKinley. I am an attorney over at Lacy, Katzen. I've been practicing in the T&E area for well over 23 years. So I got a lot of stories to tell you, and as we go through, I always like to not just be a dry presenter, but to incorporate some real life stories for you. So the first topic you click. You're gonna click?
Yeah.
Okay. You can click. Okay. Good. I don't have to do two things at once. All right. I think one more. All right. So we're going to talk about healthcare proxies, power of attorneys, and last will and testaments. That's our first topic. And I'm going to focus on healthcare proxies. So we have New York Public Law 2980, where you can do a healthcare proxy. I'm assuming most of you know what a healthcare proxy is. It's a document where you are going to name a person who is going to make healthcare decisions if you can't. And that is typically determined by a doctor, whether you're competent or not competent to make those decisions. You want to, when I sit down with clients and I talk about healthcare proxies, it's easy to say, well, do a healthcare proxy and, name somebody. But you really want to think carefully about the person that you're going to appoint, because you want to make sure that that person is not going to make the decisions that they would make, but the decisions that you would want made. So if you don't want extraordinary measures taken to keep you alive, if there's no hope of getting better, you want to make sure that person is able to pull the plug. And as I said, the healthcare proxy only goes into effect if you are not capable of making healthcare decisions. Usually a healthcare proxy is, you can have directives in it, so that's the living will provisions, or it is a healthcare proxy where you're just naming an agent. And it's presumed that that agent knows what decisions you want to make. Living will provisions are going to be statements as to what type of care you want or you don't want. So if you don't want to be put on a ventilator, you don't want feeding tubes if you're not going to get better, then you want to make sure you express that in your healthcare proxy. I have had clients who have said, I want all measures taken. I actually had a client who I had to put in the healthcare proxy. He intentionally wanted to be kept alive because he knew his wife would get the benefits. He was a veteran, and that his benefits would continue. He didn't care if he was on a ventilator, didn't care if he had feeding tubes. He wanted, it was more of a financial decision for him. Okay, that's the extreme. I had a client who basically said to me, I don't want anything done. I said, well, you're like in your 50s, you're healthy. You're telling me that if something happens to you, you have a heart attack, something happens, and you don't want to be resuscitated because you might get better, fully recover. She said, nope, it's my time to go, it's my time to go. I'm like, okay, then we should do a healthcare proxy, we should put the proper language in there, but you also want to talk to your doctor about a most form, and we're going to talk about that. Just so that's a little tidbit for what's coming. If you don't have a healthcare proxy, then there are provisions under New York State law that dictates who can make those decisions for you if you can. And that is a guardian that's been appointed by the courts, a spouse, so spouse is number 2, then a child, then a parent, then siblings, and it could be a close friend, okay, if you don't have any of the above. The problem with that is my husband's a retired paramedic, respiratory therapist, so we talk about health care and making decisions all the time. He had a scenario where he had dad who had terminal cancer, and first son came in and made the decision to put dad on a ventilator. A second son came in and basically said, my dad would never have wanted this. And he had terminal cancer. He was not going to get better. So pick the right person and make sure you talk to them, make sure they know you're picking them, and make sure they know what your wishes are and they're strong enough to do them, okay? I've been on the end of not only being named healthcare agent for clients, but also for my parents, and it's a very hard decision when you're looking at somebody that you love and you have to make that decision to withdraw treatment. So pick the right person that's going to be strong enough to do that. Medical order for life-sustaining treatment. MOLST. Okay, this form came into play, I want to say 2006, 7, 8, somewhere around that time frame. So it's been in existence for quite some time now. It's a bright pink form. It's basically a doctor's order. It has to be filled out by your doctor. And it will say, do you want to be resuscitated? Maybe there's a trial period. Maybe there's no, maybe you just want a DNR. Do you want to be intubated? Maybe there's a trial period. Maybe there's not. Do you want certain medications? Or do you want withdrawal of all treatment? So this is a document that if the paramedics are called and they see this document on your fridge, they're going to do what that document says. It's a bright pink form, so I've talked to clients about having this form. It's typically for older clients, so if you look at a person and you would be not surprised that they die in the next 6 months, that's who this form is for. Somebody that's terminally ill, somebody who is in a nursing home, somebody who is frail, okay? That is what this document is for. But I also tell clients, if you have this form and you're sitting with me in my office and you don't have it on you and something happens to you here, what are we supposed to do? You don't have it on you. I think there is an electronic version of this form, but when I have clients who have this form, I said, you want to make sure you have it on you, or at least a copy of it on you. Because you could be at a restaurant, you could be somewhere else, and if it's on your fridge at home, which is where you want to make it visible to anybody who would come into your home, emergency provider, But you also want it on you if you're not in your home. All right, next topic is gonna be, organ donation. So with regards to organ donation, you can include in your healthcare proxy, whether you want your organs donated or not donated. You can also register through New York State at the DMV to be on the New York State list. And then that is, in your record if something would happen to you. I sometimes will, if I know a client is an organ donor, I will put a provision in the healthcare proxy as well, but we want both of those provisions to match. We don't want a discrepancy between what you told New York State and what you're putting in your healthcare proxy. So if you only want donation of your eyes and your New York State registration says, oh, I'm gonna donate anything, but you're restricting it in your healthcare proxy to just donating eyes, that might be a problem, because there's a discrepancy there. So you wanna make sure you're consistent in what you're doing. Disposition of remains. This is a document where you can dictate who's gonna take care of your funeral arrangements. Who is the funeral director supposed to take direction from? I sometimes talk to clients about this. Probably 90% of the time we don't need it, but there's that other 10% that we do. I had a client who was Jewish, and she wanted a traditional Jewish funeral because she was very religious. She was afraid her son, who was not Jewish, would not do what she wanted. So I did the disposition of remains, I named her daughter, and her daughter took care of everything, and there was no conflict, we knew what was going on, and it was easy. If you don't name somebody, and there is a conflict between who can make those arrangements, then it's difficult. I'm not sure what a funeral home would do, but they're not going to know who to listen to. Under New York law, there is a statute which dictates the order of who can make those arrangements. And it is first somebody who is named in the disposition of remains, then a spouse, and with this day and age where there's a lot of individuals living together, not married, it's a domestic partner. And when you look to the evidence as to whether the domestic partner, you lived together for 20 years, you shared expenses, you basically treated each other as spouses. So they're number 2 above children. Children comes next, then parents, then siblings, then a guardian who may be appointed, any person who shares in the estate. Nathan's going to talk about intestacy and who those individuals are, fiduciary of an estate, a close friend or relative, and then the public administrator.
If you're a domestic partner, do you have to have that legally?
No. I just had a case where this popped up where person died, he had a domestic partner, he also has siblings, and the sister who was the executor of the estate did not want to pay funeral expenses because his significant other made the arrangements. Well, we just looked to this law to basically indicate that she had every right to do that, and the funeral home had every right to look to her for that. And it does not have to be registered, you don't have to be registered as a domestic partner. That is a provision in the law that if you are, then, you know, that person is considered a domestic partner, but there's also provision in the law that describes or defines what a domestic partner is, and it's really accumulation of the evidence, you know, did they hold themselves out as domestic partners? And Nathan's up.
Thank you so much, Nancy. So now I'm going to talk a little bit about power of attorney. Now, you know, one of the things that that Nancy went over with the healthcare provisions described how New York law has a lot of default provisions. So if you don't have a healthcare proxy, there's still in the law a default as to who can serve as that healthcare agent. If you don't have anybody named in the disposition of anatomical remains, there's still a default provision that we just talked about. There is no default provision for power of attorney in New York. Right? So just because you're married, or a domestic partner, or a child, or a parent of a child, does not provide any default authority to act as that person's power of attorney. Now, power of attorney is the appointment of an agent to make financial decisions for you at your direction, or if you're otherwise unable to serve, if you are incapacitated. Now, when we talk about financial decisions, this could be a broad array of things. Real estate transactions, signing deeds, signing checks, banking, making deposits, adding or removing beneficiaries to accounts, gifting property even. And so it's a very, very important power to provide to trusted individuals, and very important that the people that you appoint are absolutely trusted to make those decisions. Now, again, when would the power of attorney be in effect? Well, there's a few different types of powers of attorney. The most common that we work with is a durable power of attorney. Now, you could have a temporary power of attorney. We see those infrequently. Those are usually powers of attorney that clients will make for a specific transaction, and truthfully, it tends to be more corporate clients or business persons that maybe have one single real estate transaction that they need somebody to sign on their behalf for. The more common is the durable, and durable means it lasts for the entirety of your life unless and until you revoke it. There's also immediate versus springing powers of attorney. An immediate power of attorney is also the more common type of power of attorney that we prepare for clients. The immediate means that it is effective as soon as you sign it and your agents sign it. Once you and your agent sign it, it is currently immediately effective. Springing, though, is a type of power of attorney that might include language that says that it only comes into effect at a certain time or under certain circumstances. Okay? And again, the springing circumstances can be absolutely anything that you define in the document. It could be a specific date, could be at a specific age, or more commonly it might be at the occurrence of a specific event, such as the certification by your physician that you are unable to make financial decisions for yourself. Now, we don't often recommend springing powers of attorney because those can be sometimes very difficult for your agents to implement at the time of need. What I mean by that is that with a springing power of attorney, again, there's that condition that it only goes into effect at a certain occurrence, and so proving that occurrence could be difficult because the person who's named power of attorney might not be the healthcare proxy. And so they might go to the doctor and say, well, I need this certification. And the doctor might say, well, you're not healthcare proxy, we can't disclose that information to you. And it can just really frustrate the planning that you put together. Now, immediate durable powers of attorney, again, effective immediately upon your signing and effective for the rest of your life. Those are the more common ones that we prepare for estate planning clients. With that being said, the powers of attorney are not typically utilized until and unless the need arises. Now, I've had clients over the years where, especially with spouses, powers of attorney might be utilized while both persons are perfectly competent, mentally and physically able to do things for themselves, but it's just inconvenient for a certain person to act, and so they want their agent to act, or they direct their agent to act. One example is if a husband and wife are moving and for work, and they had a house in New York, but they were buying a house in South Carolina, and maybe one had already relocated to South Carolina for work. Well, the spouse in New York doesn't want to have to travel or mail documents back and forth to sign the deed for the South Carolina house, and the person in South Carolina might not want to have to mail stuff back and forth or travel to New York to sign the deed for the sale of the New York residence. So, as powers of attorney for each other, they could lawfully sign those deeds or mortgage or other transaction documents to make that happen, just individually in the two states that they're living in. But again, the more common occurrence when a power of attorney is put into place is if and when a person became physically or mentally incapacitated and unable to competently manage their finances. Now, there's also limited versus general power of attorney of those two types. Limited is a little bit like temporary in a way, in that it is limited just to some specific thing. Again, the example I gave of a real estate transaction, or maybe tax transactions. The general, though, again, the more common type, the general durable power of attorney provides full financial authority to the agent. Now, it has nothing to do with health care again, that's the Health Care Proxy, but it's virtually anything other than health care. I think there's only a few limitations as to what kinds of things a power of attorney agent can do on the principal's behalf. You cannot vote on behalf of the principal. That was a controversy, and there were a few cases a few years ago in different states with that controversy. You cannot vote on behalf of the principal. You also cannot sign an affidavit, a witness affidavit on behalf of the principal. And I think there's a good argument too, at least in terms of surrogate's court, you cannot serve as a fiduciary for an estate if the principal was the one who was appointed the fiduciary. Yes, sir.
If you have to deal with someone at a long distance, like down in the Carolinas or something, can they send you a PDF file? You scan it, sign it, send it back? Is that workable?
Well, for the example that I gave of the real estate transaction, it depends on each state's laws. In New York, we need wet signatures on deeds, but other states might have different regulations on that. So in some cases, yes, they could scan and mail or email a PDF, and you can sign it and then email it back, and that could be sufficient for some circumstances, but that's just an example, but could work. Yes?
Did you say there was no default to spouses as far as power of attorney goes?
That is absolutely correct. There is no default
Can you
law.
talk about that a little bit more? In other words,
Sure.
if she was to pass away, I have no power of attorney.
Well, let me make that actually brings up two questions or 2 points. One is that the power of attorney is only effective while the principal is alive. It has nothing to do with after death.
Right.
So I'm going to talk about after a person passes away and the administration of intestate estate or being the executor of a probate estate. But power of attorney is only while you as the principal are alive. Once you pass, that power of attorney agent you appoint has absolutely no further authority whatsoever.
Well, the power of attorney needs to be in writing and ready to go, in spite of the fact that we've been married for a number of years.
Correct. And the reason for that is not so much death, but incapacity. If God forbid either of you became incapacitated and you needed to or wanted to downsize the house and sell the house, and God forbid your spouse was unable to sign the deed paperwork, there is literally no default law in New York saying that you had the authority to sign on her behalf.
That's different from Pennsylvania, where Pennsylvania, the spouse is automatically power of attorney, not here.
Not in New York, no. So.
No.
Absolutely. That's why we do these presentations, because it's very important to know. Because, oh, I'm sorry.
If you
if you don't have a power of attorney and your spouse or child or whomever that you're caring for is incapacitated, you need a guardianship. And that can cost thousands of dollars to bring a guardianship proceeding because it's a judicial process. That's the default, is if you don't have a power of attorney, you become incapacitated, somebody is going to bring a guardianship proceeding over you. And that could be, I've had hospitals who have a patient and there's nobody who has the ability to sign. So they're trying to get a person placed in a nursing home and there's nobody who can sign anything, access financials, pay. So they'll petition for somebody to be appointed guardian and it may not be the person you want. So, and I also caution people, I see documents pulled offline that they just fill out and think this is fine. And I had one client who pulled the wrong form because the form has been updated at least 3 or 4 times, the statutory form. And it's like you signed a form that was, the last form, not the current form, and it's not effective. So you want to be very careful. Everybody's promoting, do it online, pull the form up, do your own documents. You have to be very careful with doing that because it can go wrong. You may not be doing it right. So, obviously my advice is talk to an attorney to make sure that it's done properly, executed properly. That's your best. Then it's taken care of.
Thank you, Nancy, because that actually kind of transitions to another point that I wanted to make, which, again, no knock against free publicly available information. That's a good thing. But with respect to legal documents like the power of attorney, there is that, what we call the standard statutory short form. Okay, so the statute itself that you can find in a law book, it has a sample form. And there are certain pieces of that form that have to be in every valid power of attorney, and I have some examples up there. The caution to the principal language. For it to be valid, both the principal, that is the person creating it, and the agents must sign and have their signatures notarized, and the principal's signature must be witnessed by 2 people. So it has to be witnessed and notarized. So the signing, or what we call the execution of the document, is a very important piece of the process as well. In pre-2021 powers of attorney are still grandfathered in and effective even though the law changed in 2021. But with that being said, if you're signing a pre-2021 form today, that's not effective. And in addition to that, depending, I talk with clients on this quite frequently. Depending on the age of the power of attorney and whether there are other things that you wanted to update, even though pre-2021 powers of attorney are still legally effective, the farther away we get from 2021, the more I tend to recommend, if you're updating anything, update the power of attorney as well. And the reason for that is that the parties that may be presented with the power of attorney are generally not attorneys well versed in the law. They're going to be your local bank teller or maybe a life insurance agent who know their certain areas, but not necessarily the areas of the law, such as the general obligations law that governs power of attorneys. And they'll look at it and they'll say, well, this is not the kind of form that my handbook says I have to take. And that's why we can't use this power of attorney, even though it's valid. And that would just, even if it does get past their legal department, it can just kind of slow down and frustrate your family and your agents. So it's just kind of a pitch to think about if you're making any updates to possibly update an older power of attorney as well. And then the biggest piece is the fact that that statutory short form, although it contains certain language that is necessary to include, does not contain all of the language that may be best to include. And what I mean by that is that the statutory short form does not necessarily contain all of the necessary gifting powers that you might want to include. It might not contain powers to add or change beneficiary designations, or to govern able accounts, or a variety of other things that I could talk about. And why is that important? Well, the modifications on a power of attorney are important, again, because the statutory short form is very narrowly construed by banks and other financial institutions. And so if you just have the standard form that you find online, and even if you sign it, get it notarized, witnessed, everything is valid, it might not contain all the powers necessary to make the transactions that you or your loved one need to have made. The biggest one is gifting, and we're going to talk a little bit about this later, and I know Christine next week is going to have a great presentation with greater detail about this. But gifting powers are one of the most important powers to include in your power of attorney, because that enables your agent to protect some of your property from long-term care expenses if you have become incapacitated and need a form of long-term care. Like I said, I'm not going to delve too much on that because we're going to get into it a little bit later, but that's really one of the key important powers. Again, there's other modifications that are allowed to be made in the modification section of the power of attorney that a skilled attorney can guide you through as to what might be appropriate. And again, one of the reasons for that is that we've had cases, I know I've had cases where the person had a power of attorney. They named their spouse or maybe their kid as a power of attorney agent. So that's good, and I just said it's important to have one. But the power of attorney maybe only had initial banking transactions and real estate. And it didn't have anything about paying taxes or filing taxes. Didn't have anything about making gifts. Didn't have anything about updating beneficiary designations or dealing with retirement accounts. It was just signing checks for a bank and real estate transactions. So in those kind of cases, if a client comes to me and says, well, my husband or my wife or my parents' retirement account administrator says I'm not allowed to make the required minimum distribution this year because I'm not, mom or dad. And I look at the power of attorney and it doesn't have that power listed. And because of that, unfortunately, if it's necessary for them to pursue that, they're still stuck with the guardianship process. So a power of attorney is good, but the best thing is a good power of attorney. And with that, I'll next want to talk a little bit about what happens after you die. So the power of attorney, again, as I said, is only effective during life. Once you pass, that power of attorney has no further effect. So what happens when you pass? Well, if you do not have a will or a trust or any other kind of beneficiary designations, you have what's called an intestate estate, which just means dying without a will, without any directions, written directions. Now, in New York, there is a default order for who can inherit property in New York, the intestate estate, and that's what we call distributees in the law. Now, we have up here some examples. So distributees, would be primarily spouse, but if you're married and you have children, whether young kids or adult kids, the children would, by default, also get a share. So if you're married and you have kids, your spouse would get $50,000 plus 1/2, but then the kids would get the other 1/2. So if you have just your house in your own name and your spouse's name is not on it, then depending on the value of your house, your kids might get half of that. Which, again, may or may not be a good thing or a bad thing, but that can be frustrating to people, to surviving spouses who thought, well, wait a second, I'm living in the house. I've lived in this house 40 years. Why do the kids own part of it now? If you don't have a spouse, it just goes to all of your kids equally. We have there by representation. That just is a terminology in the law regarding if a child predeceases or more than one child predeceases, how do the grandkids share in that? One of the things to point out is that the rules of intestacy will include your bloodline or people who are legally adopted in. Legally adopted in, and I'm gonna get to that in a moment. So people in your bloodline, so what that means is that if you have 3 kids, 1 predeceased, leaving 2 children, that those 2 grandkids would step into their parents' shoes if you died without a will. Which again, could be or could not be what you intend to have happen. If you don't have spouse or kids, it would go to your parents if they were living. If you didn't have parents but you had siblings living, then it would go to the siblings. If you had no siblings or nieces or nephews, but you had grandparents, it would go to your grandparents. If your grandparents had also predeceased, presumably, it would go to your aunts or uncles. If not aunts or uncles and cousins. If not cousins and the cousins' kids, the first cousins once removed is what we call them. But if you have no first cousins once removed, if you're the last of your line, it defaults to going to the state of New York. And in almost 20 years of practice, I've never seen anything achieve to the state of New York. But Nancy has. We actually have a case right now where Nancy's dealing with where, unfortunately, I won't get into all the details, but unfortunately the decedent died with, apparently so far without a will, still researching whether there was a will somewhere, but she died without a will. She had stepkids, not legally adopted in, stepkids, died without a will, and from researching the family tree, she's literally the last of her line. And because of that, it will default to New York State unless a will can be found. So New York State might own some land now, which is not really what most people would intend. So hopefully we can find that will, or the stepkids can find that will. But I've never seen it happen before, but it does. It can happen. So that's what would happen with you if you don't have a will or anything in place. The laws of intestacy. So I mean, what are some of the pitfalls of intestacy? You can see up there, people who are forgotten. Your domestic partner, significant other. We're seeing a lot more of that these days. I've got a couple of cases like this now. I know Nancy's had a couple of cases like this, where if you do not have a will and you're not legally married in New York or some other state, then you have no share in your loved one's estate. Even though you love the person, you may have been together as a domestic partner for 20, 30, 40 years potentially. You might have kids with the decedent. But if you're not legally married and the decedent didn't provide for you in a will, you have zero right to share in the estate. And so it would go to whoever would be next in line, children, or if not children, brothers and sisters of the decedent. So without a will, or a change in the law, that's the domestic partners are left out in the cold. Your stepchildren, likewise. Whenever I speak with clients and counsel with clients, I go through, who are your kids? Well, it's a second marriage, I've got these kids, I've got these kids. Did either of you adopt the kids from the other marriage? If not, they're just stepkids. And you might love your stepkids a lot. I have a few clients that are like, oh no, I've raised these stepkids as my own since the age of 5, but I've never legally adopted them. So you might want to provide for them as much as for your own blood children. But unless you've legally adopted them, or they're your genetic blood children, by intestacy they don't have any share in the estate. Long-term friends, some clients want to provide for friends. Organizations, there's nothing in intestacy law providing for any charities that you might care about, such as the Wood Library, or other charitable organizations. It goes to New York. What they do with it, I have no idea. But so who is included in intestacy that you might not want to have included? Well, again, potentially, as I pointed out earlier, it could be your children over the needs of your spouse. So the spouse gets $50,000 plus one half, the children get the other half, but maybe your spouse needs the money more than your kids do. Potential relatives that you're estranged from. Sadly, sometimes it has to do with kids, but it could be grandkids, it could be brothers or sisters or other people that would take an intestacy, but you might not have any significant relationship with them. I mean, I see this especially when it comes to cousins or sometimes nieces or nephews. Another big problem is intestate beneficiaries with issues. So perhaps the beneficiary is incapacitated, right? Maybe if they receive money, they can't possibly manage it on their own. Or maybe they're bankrupt, or they have a lot of judgments or lawsuits, or they're in jail. So, I mean, there's a lot of issues that can happen to a relative that if they're a default taker in intestacy, could pose a big problem to your executor and to your estate. Really, you know, the people that you might have cared about would lose a share of that money to this person that you otherwise might not. And then again, the escheating to New York State, which again is rare, but it can happen. So those are some of the pitfalls of not having any will, what we would call a intestate estate. But let me talk a little bit about, well, what is a will? What is a testate estate, as I said? You know, the laws of wills are governed by EPTL 3-2.1. Effectively, the purpose of a will is manifold. One is naming a person to be in charge of your estate and managing that money after you have passed. It's what we call the executor of the estate. So again, it's similar to a power of attorney from the standpoint of that it is a financial fiduciary, but it's different in that it's only after death. So just as the power of attorney is only valid during your life, the executor is only valid after death. And I say that because I do sometimes have clients who come in and say, well, I'm good, I don't need a power of attorney because I've got an executor in my will. And I say, okay, but that's fine, but the will only comes into effect after you have died. So if you need somebody to take care of things beforehand, that's what the power of attorney is for. So it's the appointment of an executor. And then also, it's the naming of beneficiaries to your property. And you can be specific. So you can make provisions, what we call specific bequests, whether it's of a particularly meaningful piece of property that maybe you've inherited from a father, grandfather, grandmother, something like that in the family line. You know, or it could be just plain money that you want to donate, whether to a charity or you want to provide for people who would not otherwise be your intestate beneficiaries. I have some of the legal terminology up there for you because it does get confusing even to lawyers. The distributee, as I said before, is that default provision in intestacy. But if you're giving some kind of specific cash amount or piece of property, that's what the law calls a legatee. And then if you're giving someone or some group of people a specific piece of real estate, you'll see the word devisee. Okay? And that just means the beneficiary of a specific piece of real estate. Now, something to point out as well is that whether it's a specific bequest or the residuary, meaning everything else, right? Whether it's specific or a percentage of the rest of your estate, the will only governs property that does not otherwise have a beneficiary designation on it, okay? So if you have life insurance policies and retirement accounts, all of which you have maybe your spouse, your kids, or some other persons named as specific beneficiaries, that won't be subject to what you put in your will. Those accounts will be provided to upon your passing directly to the beneficiaries that you name. Okay, so you know that's important to point out because sometimes clients will say, "Well, I want to give $100,000 to each of my grandkids, and I got 10 grandkids." Wow, okay, that's great. And they might have a $200,000 house and a $800,000 IRA. And I said, well, who's the beneficiary on the IRA? And he said, oh, it's my kids. Okay, well, your kids are getting that $800,000, and all you have left in your estate then is a $200,000 house. So you can't really give 100,000 to each of the 10 grandkids. So something important to think about is what passes into your will and what passes outside of your will. And just kind of making sure that everything that you have, whether it's passing in or outside of the will, is going to the people you want it to go to. So again, whenever we work with clients on preparing wills, updating wills, I always encourage clients to also look carefully at their beneficiary designations at the same time. Because if we're changing from, hey, these 3 kids and unfortunately one child has been estranged, so we're updating the will to remove that one child, you gotta make sure to also remove him or her from the beneficiary designations on the life insurance, retirement, brokerage account, whatever it may be. Another thing that may or may not be particularly salient is you can appoint guardians for minor children in the will. So you can, if you have a young child under the age of 18, you can nominate somebody that you trust to take care of that child. You can never supersede the child's natural parent or guardian. I say that because I have some clients who are divorced. And so as long as that person has legal co-guardianship or co-parenting with the child, the will cannot say, well, when I die, I don't care if my ex-wife is still alive, the kid's going to my sister. Can't say that. But if both you and the other co-parent are deceased, that's where you want to have somebody nominated that you trust to take good care of that child until they reach age 18. Now, beyond age 18, if the young child inherits money, you might also want to put a trust in place for that child in your will. Because whether they get it at 18 or 20 or 25, clients will often express that they have concerns about a young person receiving potentially, hundreds of thousands of dollars. So because of that, they will prepare or ask me to prepare a trust for their will, a trust that's inside of their will, which can provide protections on that money and make sure that the money is controlled by a trustee until a certain age or certain benchmarks are reached, such as graduating college or buying a home or something along those lines. So with that, I'd like to turn it back over to Nancy to talk about other things to think about, other concerns.
Thanks, Nathan. So some practical takeaways. Now that you have these 3 beautiful documents that you spent money on, what do you do with them? Who do you tell? So for a healthcare proxy, I tell clients, take a photo of yours, your spouse's, your significant others, put it on your phones, you're out of state, you're somewhere else, you have it on you, okay? 20 plus years ago, when I was healthcare agent for my parents, I kept copies in a briefcase in my vehicle, all the time. For your power of attorney and your will, have a list. I tell clients, have a spot. You have a little fireproof safe at home, you have a filing cabinet. Tell your agents where your documents are. Don't make them guess in a crisis. In that folder, put copies of your documents, put who your attorney is, who your accountant is, who your financial advisor is, who your insurance agent is, phone numbers, where you bank, where all your accounts are. So in an emergency, and they need to access that information like now, they know exactly where to go. Did I just? Are we there? Okay, I must have pushed the button. Okay. So tell your agents, inform them, make sure you have a place. You don't necessarily have to give them the document. Nathan talked about power of attorney. That's a document that is, you're giving somebody a lot of power. And it could be an immediate power. But you don't have to give it to them. Just tell them where it is and who to contact. Same thing with your will. Typically what we do is we keep original wills. But if your child doesn't know that your attorney is Lacy Katzen, and you don't have a copy anywhere, and they don't know who to contact, they're never gonna find it. I mean, we do check obits, but in this day and age, a lot of people don't put an obit in the Democratic Chronicle, or they don't list it. So, make sure your agents know where your documents are, because that can avoid a lot of problems on the probate side. And I want to talk a little bit about what probate is, because I don't know if you all know what that is. But when you have a will, it's not effective just because you have a will. So your executor cannot take that document into the bank and say, oh, see this will? I'm the executor, give me the money. No, they're not going to do that. The bank's going to say, well, you have to probate the will. We need letters of appointment. So there's a process. The process is that your executor petitions the court, they file a petition, and part of that process is your distributees, the individuals that Nathan talked about under EPTL 4-1.1, the individuals who would take of your will if there wasn't one, has to sign off on it. They have to sign a waiver, meaning the waiver says, I agree this person should be appointed as executor, I agree that this is this person's last will and testament, and I agree to probating the will. If everybody agrees, not a problem. Court's going to issue letters of appointment, and the executor's on their way with regards to administering your estate. The problem is, what if you're disinheriting a child? Or what if you don't know where a child is? Or what if you don't have anybody? I mean, I was power of attorney and for a client, she had no immediate family. She was married, divorced, no children, no siblings, she was the only child, parents were gone. She had distant cousins somewhere, but was not in contact with them whatsoever. We talked about a revocable living trust. So a revocable living trust is a document that you create while you're alive. Think of it as an entity. So it's not you, but you're the one who's in control of this trust. You're the grantor, who is the creator of the trust. We also name you as trustee. So while you're alive and fully competent, you can pretty much do whatever you want. You're either acting in the role of a trustee in managing the trust, or you're acting as the grantor who has a lot of power. You can dictate how assets are invested. You can tell the trustee what you want to withdraw out of the trust. But for the revocable trust to work, you need to make sure that your assets are moved into the trust, or at your death, they flow into the trust. So, one easy asset is your home. I have clients who have property here in New York State, and they have a second home in Florida. So we want to avoid that probate in both states, so we redeed their properties into the trust. We just eliminated probate for those assets. But if you forget to move an investment account into the trust, we're still in the probate process. So you want to make sure that you work with an attorney who's going to help you move those assets to the trust. I use a trust, the situation that I just went over where the person doesn't have anybody, but also if we think there might be a will contest. So when you probate a will, you're intentionally telling people who you may not even be connected with, or who wants to not allow your will to be probated, thinks it's not right, thinks it's not what your wishes are, and they're going to try to contest it. So having a revocable trust, it's private, its sole purpose is to avoid probate. Doesn't protect assets for Medicaid planning, which you'll hear about next week. It's private and avoids probate. and it disposes of your property at your death. So at your death, it acts like a will, except you don't have to go through the probate process. It also, there's gonna be provisions in the revocable trust that will provide if you become incapacitated. So a doctor deems you're not capable of handling your affairs anymore, there's gonna be an alternate trustee that you're gonna name in that document that can take over after you do, if you can no longer be trustee. For IRS, I'll come back to you. For IRS purposes, the IRS does not view the revocable trust as a separate entity for tax purposes, because everything in there is under your social security number. So there's no separate tax return. Any income that the trust earns is gonna show up on your personal tax return.
Does that trust have to be filed like with a clerk of a town or an entity or?
No,
Okay.
no.
I got misinformation from a lawyer.
Just one thing I wanted to add too on this is, I know there are, some folks out there that would say like everybody in the world needs to have a revocable trust. And, from our experience, many, though not all, probate estates are pretty easy to handle. The surrogates court in Ontario County is phenomenal. And I say easy to handle up here, so. Nancy? Hello? Hello? I think maybe the battery. Hello? Okay. The battery might be dying, so bear with me. But we were just at a Trust and Estates conference here in Canandaigua. Yeah, the battery died. Here in Canandaigua, and there were some practitioners down in New York City that were complaining it would take them 7 months, 8 months, a year or more to just start a probate estate down there because the courts are so backed up. That's not the case here in Ontario County, Monroe County, Livingston, Wayne County. We have phenomenal surrogates courts here who really process pretty expediently the uncontested probates. So what I would say is, just sort of a side point is, a revocable trust is a great idea for some clients, a good idea for many, but not necessary for every single client. Because if you got kids that are healthy, who all get along okay, that you don't think are gonna fight you on anything, it might not be necessary to set up a revocable trust. The two main types of clients that just as Nancy said, the two main types of clients that I will recommend a trust for is if you've got real estate or other unusual properties cited in different states, so outside of New York, that would necessitate having to do multiple probates. Or if you know you've got very distant relatives that are gonna be a pain for your executor to find and notify, or you know for a fact you're cutting 1 or 2 kids out and they're gonna fight it. And so if you know they're gonna fight it for a fact, I will encourage clients to maybe consider a trust to avoid having to notify those kids that are getting cut out.
Right.
I can try it.
We'll try it.
We'll try it.
The battery.
Okay, so, so transfer on death, deed. This is brand new, okay? It just came out in July. It was a surprise to everybody. The real estate bar, the T&E bar is like, where did this come out of left field? With regards to transfer on death deeds. This is where, and we went to a seminar here in Canandaigua a couple weeks ago, and there was even a debate on whether it's really a deed, because all you're doing in this quote deed is you're basically putting beneficiaries on your deed. So just like you have beneficiaries on your life insurance policy, you're putting beneficiaries on your deed. The problem is, it doesn't take effect until,
Do you want to change it?
thank you. All right, so transfer on death deed does not take effect until you die. It's revocable, but it's not effective until you record the transfer on death deed. So if you do it and you never make it down to the recording office, the county clerk's office, to record it, it's not effective. The other problem I see with it is if you have 3 children and you're listing all 3 children as beneficiaries and they're each going to get a third, one of them dies before you, their interest lapses, goes away, and then the property is just divided among your 2 remaining children. So you might be unintentionally disinheriting grandkids and things like that. So you got to be conscious of that. It also does not protect your asset from creditor claims of your estate. And we believe, and I'm sure they'll talk about this next week, that it's not going to be effective for Medicaid planning and preservation of assets. So again, brand new, I would caution you about, I think some of the county clerk's offices are, like they have the form there, so they're saying, oh, here, you can fill out this form and put beneficiaries on your deed. I would caution you about just doing that. This is so brand new, we're still learning, the county clerk's offices are learning as to how to deal with this deed. Let's see what other notes I have here. Oh, there also is there's no requirement that you have to put your beneficiaries on notice. So they may not even know that you did this. Again, unless you would tell them that you did this. Okay.
I have a question.
Yeah.
So that's different than if you have a spouse on it, and the spouse is on the deed, correct? That's if you were gonna like put your children.
Correct. So if you took title as Joe and Jane Smith, husband and wife, that's tenancy by the entirety. It means one of you dies, it automatically goes to the survivor, okay? You could add on to that deed your children as TOD, so as beneficiaries. Doesn't affect your interest in the property, okay? There's other deeds, other than that. I mean, you can take title on a deed as tenants in common, meaning you each have an undivided 1/2 interest in the property, in which case it falls under your will. Or if you're not married, you can do joint tenancy with right of survivorship, which means one of you dies, it automatically goes to the other. So there's different ways to do deeds, and there's, for not to get into next week's presentation, but there's also ways to put your children on your deed where they actually have an ownership interest in your property. That's used for asset preservation. I would not use this for asset preservation. This is limited to, and I'm doing my first one coming up, and it was like, this person, no spouse, he wants to avoid probate, and he wants it to go to his 3 children, and if one of them dies, he wants it just divided among his surviving children. Okay, perfect, we can do this. But for anything outside of that box, in my mind, it's a very narrowly focused tool to use. You just gotta be careful with what you're using it for.
And if I could just kind of touch on, and I'll get to your question too, if I could kind of touch on for a second, the creditor issue with that too, the creditor's claims. This is something that I think confuses a lot of clients, or really oftentimes a lot of executors, which is that when you die, the property that is in your name, in your estate, in your probate estate, or intestate estate, the property that's in your name alone when you die, is subject to the payments of any debt that you personally have when you die, your credit card bills, mortgage on the house, etc. On one end of the spectrum, or on one side, kids and spouses and so forth, you are not personally liable on that debt, right? So if the debts exceed the value of the property that's in the estate, you don't have to go out of your pocket to pay these debts that your loved one may have accrued. People get scared of that, but no, if the assets in the estate are less than the creditor claims, the creditors are shorted. That's the rule. You don't have to, there's no, I don't know, I think in Europe that may have been different centuries ago, but the debts do not follow to your family, right? But they do follow you. So on the other side of that coin, just because you have passed, in most cases, there are some exceptions to this. I think student loans are an exception. But in most cases, just because you've passed does not mean that your debts are all absolved. So if you've got a house in your name, in your probate estate, worth $200,000, and maybe your spouse is still living in it, or maybe the kids want to live in it, but you've got a $10,000 credit card debt and an $8,000 car loan that needs to get paid off, and maybe some personal debt and a medical bill, etc., and comes out to $50,000. Well, that $200,000 house is an asset of your estate, liable to pay your debts. And so the kids or spouse or whomever inherits it either has to figure out a way, get a mortgage, a home equity loan, or sell it, but figure out a way to pay for those debts out of the proceeds of that house, or out of their pockets if they want to keep the actual asset of the house intact. So that's where some of the creditor issues come into play. And generally speaking, assets that pass outside of your probate estate, so your retirement accounts that go right to beneficiaries, life insurance that's going right to a beneficiary if you got beneficiary named, those assets, generally speaking, are not going to be susceptible to the debts. Because some things such as the retirement accounts are protected under federal law, and B, frankly, creditors hardly ever go through the expense and time of investigating where these testamentary substitutes go, right? If it's not inside the probate estate, they're not going to go after it, generally speaking. But what's interesting is that in this new transfer on death deed law, the legislature specifically says if the probate estate's too small to pay the creditors, creditors can claw back that transfer on death property. So it's explicitly put in the law that creditors can go after the transfer on death deed house. So that's why we're kind of harping on, it doesn't really help protect the house from any kind of creditors. Other deeds typically do. Joint with rights of survivorship, actual present deed of the remainder interest with the reservation of a life estate, which I won't get into all the details on that today, but those kinds of deeds actually can be protective, whereas this one almost explicitly is not. So but hopefully that explains a little bit of the creditor issues. And I know we had two questions, so let me get to that before we touch on the retirement accounts. But ma'am, in the back.
Yeah, I guess I was just asking, why do we need this new legislation? Nothing is covered in all the current rules and regulations regarding everything?
So that's a great question, because that's my feeling, of course.
Yeah.
But well, so at the seminar, I think there was a young woman from a young attorney from, I think, legal assistance or legal aid downstate, and I think the idea behind the legislation was this would be a way for, frankly, poor people to more easily, who don't want to pay for a lawyer to put together a will, etc., to more easily get their house to their kids or beneficiaries. I don't know, I mean, because you still have to have a deed prepared, which should not be done by a non-attorney. A deed is a legal document. I know some states will allow title companies to prepare deeds, but New York's not one of them. So you're still paying for a deed, and you still have to pay to record the deed. It has to be recorded to be valid. The county clerk charges around, what, $200 or so to record the deed. So, is it really saving a lot of money? I don't think so. And it's creating some of these potential headaches. Another real big potential headache that Nancy alluded to, that they talked about at our seminar recently, is that because there's no requirement in the law to present the deed to the beneficiaries, they may or may not ever know that they've inherited this. So let's say, I'll take an extreme example. Let's say that you don't have kids, but maybe you're like, you know what, I love my niece who lives down in Texas, and I want to give my niece my house. But you don't tell her necessarily, but you do that transfer on death deed, and it's recorded, that's fine. And niece is sad that you've passed away, and maybe there's no will, because you did the transfer on death deed. So everybody's sad, but they wonder what's going on with that house. A couple of years goes by, the house gets foreclosed on because nobody pays the taxes on it, because nobody knows that they have to pay the taxes on it. And then later on, niece gets a foreclosure notice, maybe gets a foreclosure notice from the town saying, wait, you haven't paid property taxes for the last 4 years or 5 years for foreclosing. But she never knew she owned the house, which is different than other forms of deeds on which there is a notification provided to the buyer of the house. So that's an issue. And then,
Well, I think my question probably tags on to this as it's developed, but real estate in your name, you have children, and they were listed in the will, but obviously, once you transfer that to them, living or not, they also have the mortgage or whatever else is attached to that real estate. So how do you see this, if you do the transfer of death deed, and that's official deed, then does that have any effect on the mortgage if it's not paid off?
so yes and no. From the standpoint of, obviously it doesn't absolve you from paying the mortgage, it doesn't absolve the house from paying the mortgage. So whether it goes through the will, or it goes through the transfer on death deed, or it just goes by intestacy, the mortgage always flows with the land, we say, right? So if you have a mortgage or a lien, God forbid, but if a lien or a mortgage is on the house, that flows with the land, whether it goes to your estate, to your kids by deed, or to your kids in intestacy. But that also brings up another interesting issue, which again is if you pass having that mortgage on the house, and one or more of the transfer on death beneficiaries don't know that they are inheriting this house by the transfer on death deed, how are they going to pay the mortgage? The mortgage company doesn't know to contact your kids because your transfer on death deed isn't sent to the mortgage company. It's recorded, but it's a revocable transaction. And so yeah, that brings up an issue. The mortgage would still be due. You can't get out of that. It still flows with the land. But yeah, I mean, I think the transfer on death deed provides unfortunately, some unintended consequences that we're yet to really see how that plays out. Any other questions on the? I'm sorry. Yeah. Any other questions on the deed before I talk about retirement accounts? Yes, sir.
In terms of the heirs, let's say, we'll make it simple for children. They get the house. Nobody wants it, but they're stuck with the obligations on the home. Is there a better vehicle in terms of them being able to put it on the market right away so that they're not paying the mortgage and taxes? I mean, that could go on for months in some cases, I would think. So, and I'll end the question right there.
Oh no, that's a great question. So I think that's part of where the revocable trust comes in, because if the trust owns the house, upon your passing, the trustee has immediate authority. The successor trustee would have immediate authority to put the house on the market. And could one of the beneficiaries of the trust buy it? Sure, if they wanted to keep it, they could say, yeah, here's my money, or maybe I get a 1/3 share, so here's the fair market value minus 1/3. I want to buy it from the trust. But the trustee would have immediate authority to list it for sale, to liquidate it at fair market value. The transfer on death deed would probably also conceptually provide for that kind of immediate, well, you know what, no, it wouldn't, I'm sorry, I'm thinking out loud. Because that clawback for creditors is within 18 months of death. So that kind of, again, it's way too early to know how that will really affect things. But theoretically, that could kind of, from a title perspective, lock up that property for 18 months.
I think the
Mhm.
question would be, could they sell it and now that it goes to the
Mhm.
proceeds, you know, and then they
Mhm.
claw back the proceeds?
Yeah.
If there's a mortgage on it,
If there's a mortgage on it, so in my mind, it would be that 18-month period is, could you sell it? There's a mortgage on it, that would immediately be paid because it's an actual lien against the property. The question is then, if there's a clawback for other creditors, does that clawback transfer from the home to the proceeds? I'm guessing it would, but there could be a whole bunch of questions that brings up. What if you didn't sell it on the open market to a third party, and you had a realtor with a bidding war, and you sold it to one of the children, and you did the assessed value or you did the appraised value, which may not have been what a third party would have paid for it. So I think it's just gonna raise a lot of issues and a lot of questions down the road, and hopefully down the road, there'll be some changes to the statute to address some of that. We just don't know right now.
And all of that then is taken out of the picture if the house is in a revocable trust. Is that correct?
A revocable trust is still open to creditors.
Okay.
It is.
So, but, if you have other, but it gives the immediate, a revocable trust has been around for ages, so there's a known factor there. So your successor trustee can immediately put it on the market, can immediately sell it. Now they're holding the proceeds and waiting for creditor claims, okay? It's different than if the deed automatically transfers to your kids. You have 10 kids and they're all listed on there, that becomes a nightmare as to who's holding the money and did they spend it or do they have it in a bank account somewhere because they talked to an attorney that's gonna tell them, you better hold on to this for 18 months.
One other quick point I would add on that too is I think the TOD deed beneficiaries would cause the same title issues as intestate inheritance of the land by kids, which is at the time that you die with that TOD deed, yes, it's susceptible to your estate creditors under the law, but then it vests automatically in the kids that you named. And when that land vests automatically in the kids that you named, that's then exposes that property to their creditors. So if one of your kids, God forbid, didn't pay their mortgage, got a foreclosure, and there was maybe a deficiency judgment against them a few years ago, and they just never paid it because they didn't have the money to pay it, and they weren't able to be garnished, etc. If that judgment is still active, then when they inherit their share of the land of the house through the transfer on death deed, then if they go to sell it, the buyer is going to say, well, we need proof that this gets paid off, this judgment, because you inherited this automatically. It's technically 1/3 your house now, if you got 3 kids, 1/3 your house now, and we need proof that this thing got paid off. Whereas with the trust, revocable or irrevocable, the trust is the nominated owner of the property, so it's not susceptible to any of the kids' creditors, although it may be to the owner or decedent's creditors if it's revocable, whereas the irrevocable would not be. So, yeah, a lot of issues there. So now I want to talk, kind of change gears from houses to the next biggest asset that most clients have, which is your retirement accounts. A lot of clients that I have, the biggest assets that they have accumulated over their lifetime are really their primary home and their retirement accounts. So, retirement accounts, when I talk about retirement accounts, I'm including, anything subject to ERISA, IRAs, traditional IRAs, inherited IRAs, 401ks, 403bs. Roth IRAs, anything other than what we call defined benefit pensions, okay? So defined benefit pensions typically, although not always, some state pensions I know will have a small death benefit payment, but typically defined benefit pensions last as effectively an annuity during your life, and then in some cases, depending on what you chose as an option at your retirement, potentially some small annuity payment continuing on for your spouse's life. There's no chunk of money that you can leave behind for your kids with those defined benefit pensions. It's just the payment during your life and maybe your spouse's. These retirement accounts, the 401ks, IRAs, these are what we call defined contribution plans. So you added money in during your working years, and then once you retire, that money is available for your use, and you can pass on that money to your loved ones. Now, during your lifetime, you have to withdraw money from the account. You can't just leave it sit there and grow. There were some pretty major changes to how these retirement accounts are governed under tax law in 2020 and again in 2021, which is the Secure Act that you might have heard of, and Secure 2.0, which just made some minor, kind of revisions to the Secure Act. The Secure Act was a major change in how retirement accounts are governed. It had some good changes. Okay, so prior to the Secure Act, if you took money out before age 59 and a half, you would have to pay an extra 10% tax penalty on top of the regular income tax on the money you withdrew. Also, prior to the Secure Act, you would have to take required minimum distributions starting in the year in which you turn age 70 and a half. Post-Secure Act, and I'm going to talk about how it's been amended by Secure 2.0. Post-Secure 2.0, you don't have to start taking required minimum distributions until age 73. Now, if you turn 70 and a half in 2019, or you turn age 72 in 2020, you got to take the required minimum distribution still. But for folks just turning 73 in 2022 or 2023, that's the age that you need to start taking the required minimum distribution. So they bumped up that required minimum distribution age by a few years, which is nice. Just to kind of take a step back, what are required minimum distributions? You probably know this already, but just to define, when I talk about an RMD or required minimum distribution, I'm talking about what the income tax law literally says you are required to withdraw from the account each year. Starting at age 73, it's based upon IRS promulgated tables for your life expectancy. So you take the value of the account on December 31st of the past year, and you look at the life table as to, okay, what's my age this year? Okay, age 73. There's going to be a factor there. Maybe it's 14.2.